Hello, good evening and welcome to another program on Law and Order on a beautiful Friday evening. The program that features a specialized area on law each week with an expert guest. Today, we are going to touch upon another subject which we haven't touched upon before, and the subject today is called constitutional reform. I will leave it at that, and the rest we will answer in our discussion with my guest expert on this subject. So today my expert guest is Yuresha Fernando, attorney at law. She's the additional secretary to the Constitutional Assembly of Sri Lanka. Yuresha, thank you for taking time off and coming for the program. I know you're very busy. How are you today?
Thank you, Shanak. I'm very well. Thank you for having me here today.
You're welcome. Let's start off. This constitutional reforms is a big process, and you know, we and most laymen and people who are watching needs to know how it is done. My first question, what is the role of Constitutional Assembly?
I think your first question is also the most important question today.
Right.
And I think I will have to backtrack a little bit before speaking about the Constitutional Assembly. I think it's important to give a very quick overview of how this process began. So I think for ease of reference, we speak of three stages in this process. So initially, it started with very wide public consultations, where a committee was appointed by the Cabinet of Ministers in January 2016, headed by Mr. Lal Vijayanayaka. And there were 20 luminaries and experts who went around the country, and it is the first time in our constitutional history where we have begun a process of constitutional reform with wide public consultations. And through that process, we found that the views of the public as well as the recommendations of the committee were put together, compiled into a report, and within a brief period of about 5 months, a report was prepared and presented to the so-called Constitutional Assembly, which was in place at the time. Now, coming back to your question about the role of the Constitutional Assembly, this entire process is what I would describe as a continuing process or a continuum. So within that, the Constitutional Assembly would be the second stage, whereby the task of the Assembly is essentially to collect the views, take into consideration.
If I mean from the first phase you explained, which is the first phase?
That is the public consultation phase, which we have sort of classified into three different phases for convenience. So the second phase is where the Constitutional Assembly was set up by way of a resolution of Parliament. On 9th March 2016, Parliament itself resolved to meet or to constitute itself into a body for the preparation of a draft or preparation of a constitutional proposal for the consideration of Parliament. So it's two distinct bodies. This is a very important point, which I think needs to be noted at the very beginning, because the role of the Constitutional Assembly is more to come up with a political agreement on a document, whereas the adoption of the document or the passage of that will be by Parliament in accordance with the procedures that are set out in the Constitution, that is the 1978 Constitution, which is currently in place. So if I were to say something about the Assembly, just very briefly. So as I mentioned, it's 225 members converting itself into a body, which is somewhat extra constitutional or extra legal. And within that body, the chairman of the Constitutional Assembly is ex officio the Honorable Speaker of the House. There are 7 deputy chairmen who are appointed. You might have seen, Chanakya, in the recent debates, they used to keep changing places and different the chairman sat during the proceedings. And also there are bodies that were appointed within the Constitutional Assembly, the steering committee and subcommittees. There's a panel of experts that was appointed to aid and assist the process by giving legal and technical input. Also, I think it's important for us to consider some of the sort of features of the Constitutional Assembly. One is that it is allowed, it is not a feature but a sort of provision that is in the resolution, is that it is allowed to sit in the Chamber of Parliament. So even though it is not a Committee of Parliament per se, it sits in the Chamber of Parliament. Then also there is provision for the mace is symbolically carried out by the Sergeant at Arms when the Constitutional Assembly sits. This is the first time in our history that we have seen something like this. So I don't know whether you have noticed now the Assembly has sat about 10 times and each time the mace has been carried out, maintaining the distinction between the two bodies. Then the standing orders of Parliament have been adopted to some extent, to the extent that the resolution doesn't provide for something, then the standing orders of Parliament will have a sort of a residual effect where it can be resorted to regulate the practices of the Assembly. But the resolution provides that the procedures of the Assembly can be decided by the Assembly itself.
Right. Now, same people in the Parliament, in the same House, almost the same procedure. How would it differ? I may be answering a question, you might repeat what you said, but how is it different from a Parliament?
I think it's very important, Chanakya, because you see what usually happens is when you're making a constitution or if you're amending a constitution, it can be done in two ways. Either the government in power brings about an amendment or a new constitution, it has been done in the past, or the other option is where you get everybody involved, you make it a multi-party process and you make it across political lines where you constitute a separate body as a constitutional assembly. Now, it has been seen in different parts of the world where sometimes the preparation of the document is done by a different body and the adoption is done by Parliament, by the legislature. Certain other countries like India, South Africa, for example, where it is the same body. The same body constitutes itself into a constitutional assembly or a constituent assembly, prepares the document, where, for example, in a government process, it will be the legal draftsman, very simplistically, just trying to draw a parallel. But here, it's the entire membership of people's representatives who gather together to prepare the document. So that in itself, Chanakya, brings a legitimacy and an ownership to that document that doesn't get conferred if you simply follow the legislative process, where Parliament itself, perhaps the government introduces it as a formal bill, then the legal draftsman does the preparation, and then that's how the process is set about. So here the importance is that the entire body of legislators, people's representatives, will be involved across political lines in preparing a draft constitutional proposal for the country.
Right. Yeah, sorry. Some more to add, or shall I interrupt?
Yes.
Steering committee, there's a steering committee on this.
Correct.
Now, what is the role of the steering committee in this?
Well, the steering committee is the main driving force of this entire process. And given its composition, I think you will understand why, because there's a 21-member steering committee chaired by the Honourable Prime Minister. And if you look at the membership, what you will see is that the general political party leadership in Parliament is reflected in the steering committee. So you get people from the recognized political parties sitting around the table, particularly the leaders, deliberating on the various aspects that must go into the draft constitutional proposal. So in that context, I think I'll have to emphasize that why I said the steering committee is the driving force is because it is a steering committee that is primarily responsible for preparing a draft constitutional proposal for the Assembly to consider. Because somebody has to actually do that preparatory work. And additionally, I think there's a report, there's a copy on your table, Chanakya. There's a report that was recently out. It's the interim report of the steering committee.
I would like to show this report. This is 21st September 2017 interim report of the steering committee and of the Constitutional Assembly of Sri Lanka.
Correct.
Yeah, and this is, I just want to show this to the public. Then we can explain on this. Let's get the shot. Yeah, this is the interim report, right? Okay. So you were saying.
What that document is, in fact, it contains areas that were directly deliberated by the steering committee. So we are talking about the chapters 1 and 2 of the Constitution, nature of the state, form and structure of government, electoral reforms, executive, religion that comes within chapter 1 and 2, land, and of course principles of devolution. So there were these areas that I mentioned. The steering committee decided at one of its early meetings that it will directly deliberate on these areas. And that is how, as an outcome of those discussions, this report has been compiled, and this was tabled in Parliament on the 21st of September, and there were debates on this for 5 days, commenced on the 30th of October, and there is another day that has been already fixed. On the 2nd of December, there's another final date for debate on this report.
Right. There are also subcommittees on the Constitutional Assembly. Now, what are they doing?
Correct. So, the subcommittees, Shanakya, now as I said, the mandate for the preparation of the draft for consideration of the Constitutional Assembly is for the steering committee. The subcommittees were appointed by the House, by the Assembly, to assist the steering committee in respect of very specific subject areas which are not directly handled by the steering committee. So, that is fundamental rights, law and order, then Centre Peripheral Relations, public service, public finance, and the judiciary. So, those 6 subcommittees were appointed. So, just to give you some sort of brief conspectus of it, the 6 subcommittees were, the composition is where you have 11 members in all, including the chair. And there again you have this sort of multi-party presence. This is again a very thematic feature of this constitution process, where from the beginning to the end, even if you take the PRC process, there's people from different political parties, different ideologies. Then, as I said, the steering committee, all political parties in Parliament, same theme was followed when nominating members to the subcommittees, where you have people from different political parties who have been nominated. And even if you look at the chairman, you will see that there's a very wide diversity. For example, Law and Order Committee is by Honorable Sagar Ratnayaka. Then if you look at Fundamental Rights, it's Honorable Mahinda Samarasinha. Then if you look at the Finance Committee, it's Honorable Bandula Gunawardena. And then the Public Finance, Public Service is by Honorable Susil Premajayanta. Then Judiciary is Honorable Rauf Hakim. And Honorable Siddharthan chaired the Centre Peripheral Relations Committee. So, you see that sort of diversity of ideologies, views, everything coming together in sort of taking this process forward. So, the subcommittee deliberated for about 5 months. It was appointed, committee was appointed in May 2016, and the report of the subcommittees, which I have a copy of here, was submitted they were in 6 separate books. We have compiled a consolidated version for sort of ease of reference. So, they were submitted to the steering committee in August last year. These reports were tabled in the Constitutional Assembly by the steering committee as a document adopted by the steering committee on the 19th of November 2016. So, now both these documents, sets of documents, are in the public domain. And I think it's important to state that when the committees were deliberating, the 6 subcommittees, they were given autonomy as to procedure and process. The chairman and the members could decide. So, there was expertise coming in by the panel of experts that I mentioned, where they were assigned. There are 10 members on the panel of experts. They were also nominated by different political parties. And those experts were assigned to each of the subcommittees to support. Additionally, to ensure that there's a bridge between the Public Representations Committee process, where the consultations took place, and the processes in the Assembly, members of the Public Representations Committee were nominated to sit throughout the subcommittee deliberations to give input. And additionally, the committees themselves have invited a number of experts on subject matter, experts on constitution making. And also there were people who came before the committees, different interest groups, people from government, private sector, civil society, and particularly a committee like Fundamental Rights. There's a very wide spectrum of interest groups that came before the committees. Same with the other committees also. For example, even public service, there was one day where there was over 150 public servants who just had to come for this one meeting to discuss an issue with regard to public service. So, like that, it was a very sort of a well thought out process with wide participation, and then it is as an outcome of that sort of detailed deliberations that these reports have been finally submitted and then tabled in the Constitutional Assembly.
All you say, it looks like a people's constitution. But at the same time, with all these things being done, there are allegations, as you heard, that it's done behind a closed doors. How do you balance this? What's your take on this?
Well, given what I've been saying, Shanakya, and from where I have been watching, I think the way the resolution has been drafted, the way the process has been crafted from the beginning, the very fact that there's a that the process began with the appointment of a public representations committee, I think bears testimony to the fact that this is intended to be a people's process. And throughout the deliberations, particularly the subcommittees and all of that, there's always avenue for people to come in, give their views. Even currently, all representations received by the Constitutional Assembly Secretariat that has been set up in Parliament, as a matter of policy, as a matter of principle, we table it. Even if it's a handwritten note, it has been tabled before the steering committee. But I do understand why this allegation may perhaps arisen, because I think when the steering committee was deliberating, particularly, there was a difficulty for us, difficulty to make it a public process initially, because the idea was that you are sitting around a table trying to reach agreement on core issues that goes into the constitution. So unlike the subcommittees, there's something a little bit different there, because the idea of the steering committee was to gain agreement at least on core areas like nature of the state, the executive, electoral reforms, devolution, and so on. So if you look at a parliamentary committee, even the members' right to deliberate, the members' right to express views is always preserved. It is only afterwards that the document is made public, and then people are able to comment on it or know what the sort of the outcome is. So here, for the purposes of protecting the right of members sitting around the table to express views, there was a requirement to ensure that they were not pressurized to perhaps go with party slogans and platform sort of ideologies that will not have been conducive to a proper discussion within the steering committee. So it's no different to a parliamentary committee. So I think it's a bit of a misunderstanding in that sense. And now that the basic document is out, Shanakya, I think now is the time. This is the beginning, in a way, of a process, because the interim report is out. Basic principles and formulations have been put to the public. Now is the time to begin the discussions in the public forum. And if you look at this report, you will see the main principles and formulations are there in the report. But you will see that quite apart from that, sort of the first pages of the document, towards the end there are annexures which are political party positions, which either agree, disagree, or come up with alternatives. Now, so you will see, if this was any form of a final document, that feature would not have been there. So you will see by a mere perusal of this report, Shanakya, that in fact what you get is principles and formulations for discussion. So this whole allegation of closed doors constitution making, I think you will agree is unfounded, because there is no constitution made. Only principles and formulations to begin a process for discussion, and then we'll have to see how the political parties come together, hopefully.
So there is no draft constitution at the moment?
Absolutely not.
When there is a draft constitution at one stage, a new constitution, how is it going to be passed by the Constitutional Assembly, or will there be a referendum? What's the mechanism?
That is also a very important question, Shanika, because there's a fair amount of confusion, I think, with regard to that. So there again, we go back to the three-stage process I was describing. So a draft constitution will, in the sense of a legally acceptable document, will only come in the third phase of this process. Why? Because the whole idea of the Constitutional Assembly is to prepare a document to submit to Parliament. So when even a question of a referendum and so on comes only in that last stage. To very briefly tell you, if you look at, there is a vote that is to be taken in the Constitutional Assembly, but it's very different to the vote that is going to be taken in Parliament. What happens at the end of this second phase is that the Constitutional Assembly will vote on a draft proposal and or the final report that is submitted by the steering committee. In that final outcome, in the second phase of the process, if a 2/3 approval is given to that document, that is considered to be a consensus document.
Right.
Nothing more than that. There is no legality to that in the context of a constitution that is adopted for the country. So once that vote is taken, the assembly will be dissolved, and it is only when the same members, interestingly, meet as parliament, and then that draft bill is duly endorsed by the Cabinet of Ministers as set out in the 78, the current constitution. Then a 2/3 majority vote is taken in the House, and then a referendum. You come to a question of a referendum only at that point. But I think as lawyers we know that if this constitution is going to be passed in terms of the prevailing provisions of the 1978 constitution, then a referendum arises only in the context of what is actually changed.
Right.
For example, if certain articles in the present constitution, like Article 1, nature of the state, 2, 3, then 5, 6, 7, like that, there's about 10 to 12 articles that are set out in Article 83 of the constitution. If any of those articles are changed, then the resolution also says that it shall be passed by way of a referendum by the people.
Right.
That is the constitutional requirement.
Yes.
But of course, in good faith, the process might well end in a referendum irrespective of whether these articles are changed or not. But I think it's important to flag that the requirement arises to have a referendum in terms of Article 83 of the Constitution, and only if those articles are changed. And anyway, this question arises only at the final stage where Parliament will have to adopt this document as a constitution or an amendment for the country, but those decisions are left to the political parties, and I, particularly as an official, can only give a very brief idea of what may happen based on the constitutional text. Yeah.
This subject we have lots to talk about, but we are running out of time. But tell me, you explain to us what has been done, what's being done. What is the step forward? What are the next steps you all are doing?
Well, as I mentioned, the interim report has been debated for 5 days already. The subcommittee reports have already been tabled in the House. So the next step, according to the resolution, is that the steering committee will have to now start the work of formally beginning the drafting of a bill and also a final report for the consideration of the Constitutional Assembly. But before that, on the 2nd of December also, there is another date fixed for the debate that is on the steering committee report and perhaps some aspects of the subcommittee reports. So after that, what will happen is, once the final report is formulated, and in that sort of process or in that endeavor, the steering committee will consider the debates that emanate or the ideas that emanate from the debate in the Constitutional Assembly, then also views of opinion leaders, the Mahasangha, the different sort of political parties, members of the public. So all of that will come together in the preparation of that final report. That is why these documents are being debated by the public at this point. And when the final report is prepared, and along with presumably a draft constitution bill, and of course the expert panel will be kept very busy because all these documents are prepared by the expert panel, subject based on deliberations and discussions of the committee. And then the vote will have to take place in the assembly. So there are 3 possible scenarios that could happen if the vote is taken in the assembly. First and most favorable is that there will be a 2/3 approval. Then immediately assembly is dissolved, and the document will be sent to Parliament, endorsed by the Cabinet of Ministers, and subject to the parliamentary or general legislative process for adoption of a constitution. Second scenario is if there is only a simple majority. If there is only a simple majority, it's a little uncertain in a way. So there what will happen is still the assembly will be dissolved, Parliament will meet, document will be sent to Parliament, and within 1 month they must look at it, consider it, and then approve by a 2/3 majority. Now this 2/3 is not the 2/3 majority in the legislative process. So what happens is if Parliament approves by a 2/3 majority, then it's sent to the Cabinet of Ministers and again adopted once again a 2/3 majority, referendum is if required and adopted by Parliament. Yeah. Third scenario is, of course, if there is not even a simple majority in the Assembly, then the whole process will come to a premature end. So what's noteworthy is, from what I just said, Shanakya, is that there will be a 2/3 approval in either the Assembly and the Parliament, or in Parliament itself twice.
Right. So in that point, we'll take a break on today's discussion on this. I know we have lots to talk about it, and thank you very much for those very insightful thoughts, and we wish you success in this process and hope to see you once again as we go on doing this process in the future. Thank you for joining us.
Thank you, Shanakya.
That's Law and Order for you today, and we'll join you next week at the same time for another program on Law and Order. You can go to our website, channeli.lk, and go to the drop-down menu, pick Law and Order, and watch our programs all over again should you wish to. I'll join you next week at the same time, and have a good night.